Yeah, I think you're going to want to. I think you're going to want to do the recording when you're actually ready to start.
We're live, and we're recording. Let's give it 1 minute. I see a lot of people are joining us right now. Let's give it another minute to people to join. Okay, welcome everyone to the ins and out of Surety Bonds live webinar. I'm Mark Feld, I'm Managing Director of the Riverside Experience, and on behalf of everyone at Riverside, we thank you for taking the time today to join this webinar. The topic of today's webinar, like I mentioned, is surety bonds. It's something that I'm super excited to learn about, and we have some really great people here to lead today's discussion. We're going to be joined by Neil Peterson, second generation owner of Peterson and Sons Surety Bond Agencies, as well as Ariel Weinstock, a partner at Caskey and Corrance. This event is brought to you by the Riverside Experience and the Riverside family of companies. Riverside's motto is that we are more than just a title company. We are your partner in helping you get your deals done. When everyone else says no, Riverside says yes. And while others are pulling back, Riverside is fully up and running, getting things done for their clients, whether it's their top-rated title services, 1031 exchanges, or cost segregation. Riverside is there for you. And did you know, by the way, that Riverside has a soft deposit fund that assists their clients in helping them put offers on new deals without tying up their money. And now we're going to turn over the program to our lead panelist, Neil. So Neil, why don't you take it away?
Thanks, Mark. Welcome, everybody. I appreciate the opportunity to educate you about surety bonds. Like Mark said, my name is Neil Peterson. I'm one of the owners of Peterson and Sons Surety Bond Agency. A little bit about our firm. We were established in 1992 under the name Offenhartz and Peterson. My father's business partner, Carolyn Offenhartz, retired in 2012, 2011, and we changed the name to reflect the new ownership. We're a family-run business. We try to offer the highest level of service. What that means to me is, I provide everybody with my cell phone number. So if you need something in the middle of the night or at 7 a.m., you can give me a call and hopefully I'll pick up and we can put something together. I've put together some of the largest matters I've ever worked on after 7 o'clock at night and, before 9 o'clock in the morning. We try to approach every matter with an intelligent underwriting approach. We try to underwrite the client's financial basis and the actual bond itself. So we try to do a two-pronged approach where we look at what's the actual risk of the bond, how can we minimize either the premium or the collateral that's being required, and then we move to the financial statement to get the deal done. We also actively pursue professional designations. I myself have an associate in risk management and an associate in surety and fidelity bonding. Both are administered by the Insurance Institutes of America. I think they're now called the Institutes, but they're the highest educational insurance designation entity out there. Like I said, we answer our phones after normal business hours. I will give the caveat: if you're an associate at a large law firm and you're calling me from a office line, your general law firm number may show up on my phone, and if I don't pick up, leave me a voicemail with your name and your direct dial, and I will get back to you. Jumping right into the bond, we'll get into the purpose and use of a bond in a second, but lastly, we also try to keep in mind something that, if you're in a situation where you need to either bond a judgment, get an injunction, discharge a mechanics lien, and, we understand that your client's not happy that they have to pay money for something that they believe is not their fault, or that they feel aggrieved and it was, something was against them. So we try to take that into account when you approach us for a bond. So we're also trying to keep in mind the client's mindset when they contact us. They may be unhappy to begin with, so we try to manage their expectations so that we can keep them the most happy they could possibly be. The purpose and use of a bond. A bond is a financial guarantee. It's an extension of credit. So a lot of people hear bonding and insurance, insured and bonded. Well, the insured aspect is if you have an insurance policy and there's a claim, the insurance company expects to pay out on some of their policies, and they're not going to turn around and sue you for the money they just paid out. Whereas with a bond's not an insurance policy, it's an extension of credit, so you're applying for a credit guarantee. If there's a payout on the bond, the surety will turn around and sue your client to recoup the claims that they paid out. So that's the main difference, right? So we have three parties to a bond, which is the surety, who's the actual entity that guarantees the principal will perform certain obligations, whether that's pay money, build something, guarantee damages in the event someone's restrained from doing something. And then there's the principal, which is the entity that's applying for the bond and that's required to perform certain obligations. And then lastly, there's the obligee, which is the party that's protected by the bond. And that's going to be a reoccurring, those three entities are going to be a reoccurring theme throughout this presentation. So we're going to constantly be referring to the surety, which is the entity guaranteeing that the principal will perform, the principal, which is the entity required to perform, and then the obligee, who's the party protected. And like I said, so if the surety has to pay out on behalf of the principal to the obligee, the surety is going to then turn around and seek to recoup the money from the bond principal. Another thing is the bond protects the court or the obligee. Those are the two major items, and a bond can be a tool of negotiation. In exchange for the surety guaranteeing the principal will perform certain obligations, they're going to require the principal to execute an indemnity agreement, pay an annual bond premium, and possibly provide or deposit collateral of some sort with the surety. So the surety is going to look at the principal's financial wherewithal to make sure that they can pay the surety back if the surety ultimately pays the obligee for an obligation. Why are bonds required? So bonds are required to protect the obligee in the court. So, this presentation is going to be focused on bonds for judicial proceeding and court bonds. There's also probably about 1 million different types of bonds out there. So this is, we're going to cover about 5 to 7. They all have similar themes, but not every bond is related to a court case, and I did want to say that. Another thing, I just wanted to quickly define my role in the situation. Surety is a brokered business, so my office is an agent for about 12 to 15 different sureties. We can approach any one of them for any type of obligation. So don't think of me as the surety, think of me as the person representing the surety. Bonds are required to, again, protect the obligee or the court where the action of one party can have a significant impact of another party. So if we think about injunction bonds, right, they're in order for the court to grant the injunctive relief, there needs to be some sort of protection to the party being enjoined. If later that the injunction was, determined that it was granted improperly, fiduciary bonds, are usually related to estates. You have an administrator appointed to the estate. The court grants that appointment upon filing the bond, and the reason they do that is that the court has no ability to underwrite whether or not someone's properly qualified to be an administrator of an estate. They require the bond to make sure that some, third-party company said, oh, you're required. So ultimately, the bond is ordered by the court to protect the court for a mistake, but ultimately the mistake would fall on the obligee, which is why the bond protects the obligee. So an injunction would be the enjoined party. With an administration bond, it would be the heirs or the distributees. Lastly, an appeal bond protects the judgment creditors pending the appeal from insolvency on behalf of the judgment debtor. The granting of a stay pending appeal, so preventing the execution of a judgment, is allowed, but it's only allowed if there's proper protections in place for the party that's not receiving their money. I touched on earlier that a bond can be a tool of negotiation. I've dealt with a lot of head of claims of insurance companies, really interesting lawyers over my more than a decade career in this business. And a lot of times they've told me that they will offer a relatively small sum as a settlement once a matter is bonded to see if the other side will take it. And the reason being is, payment of some money today versus payment 2 to 3 years down the road. If we look at a mechanics lien as an example, which I'm sure everybody who's attending today has dealt with a mechanics lien once or twice in their life. if not more often. You have a mechanics lien against a property. You can't give clear title. You can't refinance the mortgage. It's in a violation of the mortgage. You can't sell the property. You cannot encumber it. You cannot transfer it. This is a major problem for property holders, especially commercial property owners that want to refinance the mortgage to take advantage of the low rates that are currently out there today. So, you know, if you have a lien and you can't refinance with that lien, you have a couple options. One is to settle the case. The other one is to bond it. And the other one is, I think you can possibly deposit funds at the court, but do that at your own risk. The one I want to focus on today is bonding it, right? So if you bond it, the other side's eventually going to have to foreclose on the lien and the bond to actually get payment. But once it's bonded, the bond's substituted for the lien so that you can give clear title. With that being said, you know, a court case could take 2 to 3 years, and given the current COVID environment, it could be delayed even longer. So once something's bonded with a mechanics lien, you know, the lienor, who's a contractor, may be more willing to step in or come to the negotiation table and say, oh, well, those change orders weren't really needed, or this wasn't really needed. I'll take 50,000 instead of 100, and we'll call it a day, and everybody will be happy. So I'm trying to, you know, make you aware that if you're not receiving payment today versus 2 to 3 years down the road, you may be willing to settle for a lot less than you were previously willing to settle for. The same thing with an appeal. Most individuals and corporations are not in the business of litigating. Maybe if they're a patent troll or some other entity that does that for a living, they might be more interested in you know, continually litigating a case. But most entities and people are not actively litigators, and they aren't normally involved in litigation. So once they win a case and they have a judgment against, let's say, your client, and then you decide to file a notice of appeal and issue a bond, that continuation of the case for another 2 to 3 years, which is probably a very stressful time for everybody, you know, they may be saying, well, we're willing to take 70, 80 cents on the dollar to just get done with this, you know, today or 3 months down the road. And again, payment today versus payment years received later.
It's a good indication that the person that they're seeking to collect from are prepared to dig in, and they're not going to roll over. They've put a little money into this, and it doesn't just give you leverage. It takes away the leverage of the person that's seeking to tie you up by filing the bond, by filing the lien. So it lessens for them. It gives it to you, and it's an indication that you're ready to go, and that any expectation they had that you were being held up from moving forward with your plans needs to go out the window.
Thank you, Ari. And the whole thought process being is cooler heads may prevail down the road and come to a easier resolution and a beneficial resolution for everybody. Best practices for bonding, which is something I try to harp on. I can be a bit preachy on it. If you are motioning the court for, let's say, an injunction, and there's a question for Michael Troisi. Usually with the mechanics lien bond, the premium is paid for 1 year. What happens to the bond and the mechanics lien after 1 year? If the bond automatically renews until I'm going to get into this a little bit later, but the bond automatically renews until it's canceled. The premiums due annually. It would be up to the attorney of the lienor to go down to the county clerk's office, print out the docket, find out whether or not the mechanics lien has been renewed. If litigation started, the lien's automatically going to renew, and the premiums due every year until it's ultimately resolved.
Just be a little bit clearer. In my experience, there's no surety that's going to take their bond away, or they can't take their bond away while that lien is there. So even if it's a stale or expired lien, you're going to need to get it discharged and actually removed off the docket before they'll stop asking you for a premium.
Ari does have a point in certain ways. That also usually depends whether or not the surety is holding on to collateral.
Yes.
Because if they're not, they may take an attorney's affirmation explaining that the lien's expired. This is why there's no longer any liability, and they'll hopefully close their file. attempt to have your client pre-qualified for a bond before you make the motion. So the reason I bring this up is a lot of times there are certain situations where, so the next question is, does that mean the bond continues even if the next premium is not paid? A bond pursuant to a court order or a court case cannot be canceled absent the area of law that it's pursuant to no longer being in effect. So if either you need a court order, a settlement, a satisfaction, or something else, if the bond premium's not paid, the bond continues. Now, there's an indemnity agreement in place so that if there's a non-payment of premium, they could start a commercial collections proceeding, they could retain outside counsel, they can make a demand for collateral, and this is all going to be charged to your client eventually. An example I had with a mechanics lien, it was a $17,000 lien. The client, it was my only loss with one company. The client, the surety ultimately paid out on the $17,000 lien. I think they billed $50,000 in attorney fees to collect the $17,000, which was ultimately awarded to the surety, and the surety ended up collecting $67,000 from the client. So your client has the option of not paying, so does everybody with everything, but it generally does not, it's generally not beneficial not to pay the surety. That's what I'll leave it at. Again, best practices for bonding: attempt to have your client pre-qualified for the bond. What this means is if you know that you're going to have a judgment against your client 2 weeks down the road, you want to line up everything for the bond. If they're going to pursue a notice of appeal, pursue an appeal by filing a notice of appeal, you want to have everything lined up ahead of time so they can know exactly what the terms are going to be for the bond. And if, you know, something I was speaking to Ariel about the other day was if you have an 881 proceeding and you're trying to gain access to an adjacent property, before you make the motion, before you negotiate the either the license fee or the bond amount or anything to that effect, you should have your client pre-qualified for this, that you know exactly what your client's terms for the bond are going to be before you start negotiating that or motioning the court for access. The same thing with an injunction. If you're gonna seek an injunction and there's definitely going to be a bond, you want to have your client pre-qualified for the bond before you go in, because if your client cannot obtain a bond, you may not want to make that motion. And especially today with everything being so competitive, if your client does not have the financial wherewithal to obtain the bond, they may not pay your legal fee for that motion, and then they can create tension between you and your client. So what would be needed to pre-qualify your client for a bond? Your client could complete a bond application and provide a financial statement, and you could provide details about the case, and we can get an idea of what the terms will be for the bond itself. I've had a lot of clients that, you know, call me up and say there's going to be a judgment entered against my client in a couple days. We're going to need to get the bond immediately. Let's say in New York State, you have no safe days before a judgment can be executed once it's entered. So if the other side restrains assets, it could be a very difficult situation if assets are restrained. Your client may not be able to obtain the bond.
Neil, if I could stop you for a second. When your client comes to you and you know it's a matter that will likely involve a bond, and so before you spend the time, you want to make sure that they'll be able to qualify for the bond before you write, you know, whatever emergency order you're looking for. Can you give some examples of what would be red flags for an attorney to keep in mind in terms of making a judgment or an assessment that this client probably has or probably will have a difficult time getting a bond, and maybe we need to address this now?
So there's certain clients that are barred from certain projects, and they would be you know, applying for federal projects and different things with, let's say, you know, construction case where if you're barred from getting federal funds, you know, that would be a red flag. Another red flag that comes up are companies based in certain countries. So a lot of times my office is approached by foreign companies, and let's say a company based in China, for example, U.S. surety companies have no ability to perfect indemnity of either Chinese companies or Hong Kong-based companies. And expanding on that a little farther, they also have difficulty with companies based in the Cayman Islands, the British Virgin Islands. So a lot of times companies are based there, all their assets are there. If they don't have any U.S. operations or U.S. assets, it's going to be difficult for us to obtain the bond on their behalf.
Right. I also wanted to get at if you could talk about the non-financial considerations, right? Because these are sort of credit risk assessments, and people should understand it's more than credit risk. So there's headline risk, and there's a couple other risks that pop up if there's something in your client's background that's let's say a surety company is going to do a quick Google search, because everything's on Google today, about your client. If they're extremely litigious, if they fight everything, and especially with creditors, we are extending credit. We do look at that and say, okay, every single creditor he's ever gone into a contract with, he's sued or has sued him. That's a major red flag. And there's also headline risk for certain companies that have negative connotations associated with them for certain things they've done in their past, that maybe a surety would say, we just really don't want this client as a client of ours. So those are things that tend to pop up. Did that answer your question fully, Ari? Yeah, So they may have money, but that doesn't mean that they can get a bond. So that's why part of best practices is pre-qualification, because it's not just about the ability to pay the premium. And I can tell you one of my best practices for bonding is to call Neil, who I call all the time at all hours of the day. And we go through this stuff. We explain who the clients are, and what the situation is. And just this past week, we discussed a couple of options, and Neil's advice was that a bond was not the right product, and so we're not going to be getting the bond. So I would make sure you have Neil's phone number. He knows a lot and has been a very good tool. So that's one of my best practices.
Thank you. Bonding considerations. So we talked about the requirement of a financial statement for a bond, because the bond itself is an extension of credit or a financial guarantee. I just want to quickly define a couple different things. There's public companies and there's private companies. A public company, a financial statement is generally not required, because their financial information is all over the internet. They're rated by rating agencies. There's a lot of detail about their credit history, what their cash position is, and how much money a year they make, all this other client stuff, and their current debt outstanding. Whereas with a private company, this information is generally not online and not easily accessible. So if you're representing a public company, you probably would not need to provide a financial statement, whereas with a private company, you would probably need to produce a financial statement. There's also something that's becoming more and more relevant these days is insurance coverage. So my office has been specializing in dealing with matters where a bond is required that involves either insurance coverage for the premium payment or insurance coverage for that requires the insurer to indemnify the surety for the bond, or both. And something I want to bring up is a quick anecdote. Again, so a lot of us probably think about insurance coverage, a slip and fall, at a building or property insurance, and that's covered. And if there's ultimately a judgment entered against the property, the insurer should step in, provided it's provided for in their policy, and obtain both the bond and pay the bond premium for the appeal. That's one case, but there's also, we're in an ever adapting, ever changing world where there's more and more coverage for things that people normally would not think of. I was involved with a matter where a client called me up and said, the managing agent for my building, my co-op building, lost all of my proprietary leases and original co-op shares. And the board's telling me they're not going to allow me to mortgage any of my co-ops, and they owned probably like 30 of them, in the building without a $5+ million bond. And I went through the process of getting this client qualified for the bond, and it turned out that, the premium payment for the bond was a six-figure sum. And the client looked at that and he said, what can we do to get the price lower? And there was nothing to be done. It was the price. And so he started suing the co-op board to have them pay the bond premium because it was their fault. They lost it. They should be the ones on the hook for this six-figure amount, sum of money. Ultimately, the attorney for the co-op board realized that there was a insurance policy protecting the co-op board members themselves for this type of situation. The insurer ended up paying most of the bond premium. I think my client bared less than 5%. And, it was $100,000 savings for the client where they didn't have to pay a bond premium for that situation. And everybody involved was very happy. So I'm bringing up insurance coverage because it's something you should be aware of, right? So we're having, there's data breach policies. There's a million different policies today, right? Because insurance keeps on pushing outwards. What type of policies can we come up with to protect your risks? Those risks may cover a judgment or another situation. So it's something to be aware of.
Right. If there is a professional involved or a license involved, and it's a matter of somebody's mistake, then you should be thinking about malpractice, professional liability, E&O, those types of coverages, which may provide, as Neil was saying, they may be on the hook and willing to pay the bond premium as opposed to paying the full cost. So managing agent issues, architects, attorneys, there are other places to go to for payment of the bond premium.
Thank you, Artie. I jumped ahead a couple of slides, right?
We're on 8.
Here we go. The next part of the presentation, I want to cover a couple different more common bonds you'll find in litigation and bonds that are related to real estate. So we're going to go over TROs, injunctions, appeal bonds, discharge and mechanics lien, and receivership bonds. TROs and Yellowstone injunctions. A TRO is obviously shorter term. There's less risk of loss. It's easier to obtain. With the TRO, since we're under, my office uniquely understands these. I issue a lot of them. They may be $500, they may be $1,000, they may be $10,000. I'm not saying I issue a $150 million injunction every week, but what I am saying is I issue a lot of TROs. So we know that they're very short term. So if you have a $1,500 bond or a $5,000 or $10,000 bond, if the temporary restraining order was ultimately granted improperly, it would be very difficult to prove that there are damages in court for, because of the TRO. So the TRO bond itself, and an injunction bond itself, guarantees for damages in the event the court order was granted improperly. These damages must be proved in a court in a whole separate action and trial. So the likelihood of that going ahead and happening is very small. Since my office understands this, we may waive the requirement for a financial statement for a nominal size bond. We'll just say, we'll skip it. Sometimes we even skip the bond application just because it just doesn't make sense for anybody to do the work of filling out the application or getting the financial information together. And TROs also, if you think about it, they're supposed to last like 10 to 20 days at most. So how much damages can be sustained within that time? It's also something you want to be aware of if you're motioning the court for one of these. If you can relate to the judge that it's such a short amount of time, where would the damages come from? Hopefully they won't require a large bond, or it'll be a very, very minuscule bond. Yellowstone injunctions and preliminary injunctions, they're much longer term. They can last several years. There's a greater chance of loss. The likelihood of having sustained damages due to the injunction, because it went on for several years, is a lot higher than if the bond is only, if it was only in place for 10 days. So that's why a financial statement will generally be required for an injunction, but may be waived for a TRO. We went over earlier today why your client should be pre-qualified for a bond. And again, I mentioned I can be a bit preachy on this, but why are you motioning the court for this emergency relief? Like Ari said earlier, if either your client can't obtain it because of the financials or there's something in their character where the surety does not want to do business with them. So these are something to be aware of. And also the CLE code is surety. So SURETY, just so you know, surety code is, sorry, the CLE code is surety, not the surety code, but the word surety is the CLE code. So back to the presentation. I'm mentioning how do we limit the risk of the bond? So the bond's 3 pages. Generally, it should be 3 to 4. Sometimes it's 5, but it's generally 3 pages, with the first page being the actual body of the bond and what the actual obligation is about. So you have the insurance company's name at the top. You have the caption, probably a bond number at the next couple inches down the page. And then you have the meat of the bond, which is the, either 2 to 3 paragraphs. And, in the first paragraph, generally it starts out, whereas by a court order, whereas by decision and order, whereas by judgment, whereas by insert whatever the document is that's granting this relief. And it states, Judge so-and-so, Judge Weinstock, signed this court order on the 7th day of January 2020, granting the injunction which enjoins party, whatever the defendant from taking certain actions upon the filing of a bond in the amount of $25,000. With the Yellowstone, if the judge is only granting Yellowstone for certain actions, and the judge may list that out in the court order, my office actually copies and pastes it directly from the court order. We try to be as specific as possible. So if it was ultimately determined that the injunction was granted improperly, and the other side has to claim damages, and they look at the bond and they say, well, the bond only protects for these 3 things. Well, I can't really prove damages for those 3 things. It may discourage them from moving forward with a damages action to prove damages on a bond. Something that I did yesterday, right? So a client called me up and said, I need a $25,000 preliminary injunction bond for my client. They sought an injunction enjoining their neighbor from removing a fence. And it's stated specifically in the court order, whatever the 123 Main Street is enjoined from removing the fence between 123 Main Street and 124 Main Street, which doesn't make sense. So it'd be odd, like what 123 and 125 Main Street. But so I sat there and I looked at this court order, and he said, and this is like a residential house in Long Island. This isn't commercial fence, protecting a prison or something. This is like 2 neighbors, they're fighting. Judges love tossing bonds at them, especially in the $25,000 range, because it's an amount where if you have to get that bond, you may actually have to think, do I want to continue with this fight with my neighbor? But I stated specifically 125 Main Street's enjoined from removing the fence pending the duration of this action, and the bond's guaranteeing damages for that. If you think about it, how are these neighbors eventually going to prove damages if the injunction was granted improperly? And especially since I made it so specific just to the fence, because it's just so specific to the fence, they're not going to have a lot of options to prove damages at a later date because of it. So again, you want to limit the risk with the bond. You want to push the envelope or the limit of what you can do with bonding. State specifically what's in the court order. There's not going to be, how can the other side challenge that if that's what was written in the order? Ari, I think you might have something to add.
Yeah, I was going to say that don't just think of this as, this is just something that protects the surety. I don't really care. Recognize that any dollar the surety spends is a dollar that's coming out of your client's pocket. So this is a case of good for the goose. And if you're getting a bond, you want to keep it as tight as Neil's saying, so that way it's less likely the surety, someone will call in the surety, because the first thing they're going to do when they get called is come to you and ask you to go get an attorney. and start protecting them. And certainly if they spend any money, they're going to come to you and have you pay that. So you want to be thinking as a team in that regard.
Thank you, Ari. Discharge of lien and release of liens. This is one of my favorite types of bonds. I don't know why, but my office, it seems like we issue one a week or 30. There's no in between. A general contractor is fired from a job, and that general contractor may have 10 subcontractors, 15 subcontractors, 30 subcontractors. If you don't pay your general contractor the full amount, he probably hasn't paid his subcontractors and their suppliers. I just checked my phone while I was in the middle of this presentation. I have a client in Rockland County that last week I issued 15 bonds for him. A lot of them were small, but they were still 15 bonds, and he just emailed me with 4 more liens. So he got into a dispute with the general contractor. He was fired. Every single supplier filed a lien against this individual's real estate development. He cannot sell these properties without having the liens bonded to allow for the sales to go ahead. So again, I issue bonds on a national level. Most of my business is in New York. That's where my office is. That's where a lot of my transactions take place, but I've issued bonds in other places. Now in New York and New Jersey, the lien is set at 110%. This is important to note because you go to other jurisdictions, you may have to have the bond set by motioning the court. You may have to stipulate with the other side to set the bond amount. There may be different ways of having the bond set, but in New York State and New Jersey, the bond is set by statute at 110%. I mentioned title companies here. Sometimes title companies offer to hold 150% to 200% of the lien amount in escrow. Right off the bat, this is not an exactly attractive proposition because you have to put up more cash in escrow to get the bond compared to using a bond that's capped at 110%. A lot of times, if this is left unresolved, title companies may tender a check to the lienor after 6 months. Again, I really don't think that this is an attractive, title companies aren't doing this to be mean or anything. They're looking to get the transaction done and keep their client happy. And the client may come up with, why can't you just hold it in escrow? And this is when they tend to agree to it. That's generally not good because you're creating tension between the seller, their attorney, and the title company. As far as I know, there's no provision to have mechanics lien funds escrowed with the title company where there's a provision that sets a bond at 110%. There's a statute, there's case law on it. The bond proceeds.
Even if they were going to take 100%, you're still tying up 100% of the money.
That is true, but there's also no, right? We don't have, right? There's how many mechanics liens have been litigated in New York County? 1 million, 10 million, right? I mean, it would be interesting if someone actually had that data. So there's a million transactions where there's case laws for bonds just in one county in New York State alone. So it's to me, a bond's always a much more attractive proposition. So the bond proceeds will be held until there's a final resolution of the case. The surety's underwriting considerations, they don't look at the, a lot of real estate companies are illiquid. They want to see some sort of liquid considerations on these books, but they also try to take into account the whole picture between the gross value of the assets, less the debt, and then what is liquid. So that's what they look for in their underwriting. Filing and discharge of lien.
I think you jumped. Yeah.
Yeah,
and also it's not just for a sale, right? You also have a lender, and if you've got just a going concern and there's a lien filed, very often commercial mortgages, the lender will allow you an opportunity to dispute the matter without having to just pay whatever the lienor is claiming. And in those instances, it's very common to find that the lender says you can dispute it so long as you deposit either whatever the lender wants, or when you catch that provision and you negotiate, they'll take 110, 125%. But like I said, that ties up every dollar. And if you instead go with a bond, you're tying up the premium, you're maybe tying up some collateral, but it's usually less than what either the lender is going to hold to allow you to dispute it, or what a title company would hold if there's a refi or a sale.
Thank you. I mean, that is true. Generally with mechanics liens, even if I was in a position where a surety would say full collateral, I would do my best to whittle that down to 85 cents on the dollar instead of 100%. So I think off the bat, you would be able to tie up less money with the through a bond compared to any other process to satisfy the requirement. Something I want to just remind you, the CLE code is surety, and Mark Feld is going to send you an email. You need to make sure you respond to that email from Mark Feld with the word surety to get credit for this presentation. Moving on to filing a discharge of lien or release of lien bond. We have this lovely unified court system in the state of New York, and every county throughout the state of New York has a different process for filing the bond. So if you go to New York County, they have the most strict, they have the most standard process of, you have to purchase an index number, you have to serve the lienor via certified mail prior to filing. You also need to either include an affidavit or affirmation in support of the discharge of lien by bond. You also have to serve a copy of the lien in that package that you're serving on the lienor who filed the lien via certified mail. So you have this whole packet that you have to file just to get the bond accepted. Then once you bring this in, they may look at it and say, well, you have an LLC signing the bond itself, and a lot of people like to use the word authorized signatory. Authorized signatory is not accepted by the New York County clerk unless you provided the LLC operating agreement. It clearly spells out that, let's say, Peterson Realty LLC, Mark Feld signs as the authorized signatory. There needs to be an operating agreement for the LLC that allows Mark Feld to sign for, as an authorized signatory on discharge mechanics liens. That's how difficult, that's how strict and specific the way the New York County Court handles filing a bond to discharge mechanics lien. One of the ways of getting around providing the operating agreement, if you list the person signing as either a member or managing member for the LLC, those are the only two titles that the county clerk will accept without proof that they have the authority to sign on behalf of the LLC. This is just something to be aware of, because you don't want to have to send down your court clerk multiple times to the court. Sorry, someone asked what was the code? The code is surety, SURETY. You have to respond to Mark Feld with the word surety. So moving back to right, you're sending clerks down to have this file to give to cure the mechanics lien, so that it's the bond substitute for the lien. You don't want to have to send them down 3 to 6 times, especially in the current COVID environment where the court clerks are not taking, right, they're only taking a certain amount of people a day, they're only looking at a certain amount of files a day. You don't want to have to send someone down 3 to 6 times and expand this process out like 6 weeks. You want to get it done right the first time.
Just a word of caution that the Bronx County Clerk's Office is by and large closed. It is near impossible to send somebody in to get to file a bond. They have, there's e-courts, which is for those standard actions. They have recently instituted for anything that was not previously handled under e-file. There is now a separate electronic sort of case management system that you would use. But we have, the bonds, filing a bond, getting an index number and filing a bond is not something that they will accept through that secondary system either. So we sent somebody down a few times. We got a service company to try to have them do it. They went once or twice and said, they're tired of getting turned away at the door, so they're not going to go anymore. Ultimately, we emailed with the clerk, and they said, well, you have to FedEx the original bond in, because you can't just send them a copy. You need the original, and so you have to FedEx it in, and cross your fingers. That was we FedExed it over a week ago, with a self-addressed return envelope, and I still have yet to hear. So it is a disquieting process in the Bronx, and I would check with the clerk before you start sending your people down and wasting everyone's time as to what you're going to be able to do, and hopefully it ends soon enough.
Hopefully it does. I had a question from the floor from Sheldon Krause. How many of the bonds you're issuing are backed by cash collateral? Many real estate developers are using special purpose entities because they have a deal with various investors. They may not have the balance sheet or certainly not much liquidity. So Sheldon and everybody, we really take everything on a case by case basis. So I can't really speak to a completely obscure entity, but everything in real estate, especially with a major development, you're going to have mechanics liens filed, disputes in construction. We look at what's your inventory on the condos that haven't been sold. What are your available lines of credit? What was the gross value of the construction loan? How much has been drawn down on? Is there a higher tier entity to also guarantee the bond? It really depends on a lot of factors.
Or principal, right? The managing member themselves, like the sponsors. Once you get down to an individual level, their SPE doesn't have any money, but they've got something that they can show, or they can put up some money, and they're going to individually indemnify the surety.
That is true, and sometimes on the larger scale of corporations, they have a holding company that sits up towards the top. We'll look at the whole picture, and we also try to look at what's available in your lines of credit, what's available on the leftover on the construction loan, especially if some of the liens are filed earlier on in the project compared to later on if you're just starting and there's a large construction loan that you could draw upon for liquidity to satisfy them. Since I'm going to try to speed this up.
I just want to cover that. You're going to have a conversation with the lender if you're trying to draw down on a construction loan to pay a bond premium or post bond collateral. So it might be technically available as an option, but I would not bank on construction funds going for a deposit on somebody else's protection. So I would look more towards the individual and that indemnity than loan proceeds.
That is a good point. Although I'd argue that if you have a lien against the property from the project, it is related to the construction. But Ari's the expert on the law here, so I'll let him take that one. I'm going to try to speed things up because I want to get into a very important part of the presentation. Sorry, I think I have another question. Okay. Appeal bonds. I'm going to try to run through this in a minute or two, and I may not be able to cover everything, so you may want to, if you have any questions about appeals and you deal with them often, you may want to reach out to me directly, and I could hopefully prepare some additional information. You have a bond, right? And this is going to be for any state or federal, depending on the jurisdiction. Post-judgment interest rates are included in almost every statute or CPOR out there by state to be bonded. So if post-judgment interest is required to be included in the bond, that's interest that's going to be after the judgment's been entered. The bond amount's going to vary because these amounts vary. So New York State is 9%, Texas is 5%, New Jersey's tied to the federal funds rate. Federal post-judgment interest is tied to the federal funds rate. These amounts vary. So if 3 years down the road in New York State, 1.27 is going to be owed on the judgment compared to, let's say with current interest rates, maybe like 1.6 or 1.8 in New Jersey. So because of that, the bond amount's going to vary by state. Bond amounts can be set by motion. The stay is actually granted upon filing of both the bond and the notice of appeal. It's not granted if only one or the other is provided. There's a lot of stays for use and occupancy. You want to make sure that not only the rents provided in that, but also any damage to the property. There's different things. I was speaking with an attorney about he had to get a stay for use and occupancy quasi-Yellowstone injunction for a gas station tenant, and they got a bond for the amount of unpaid rent and what the rent would cost for the next year of the litigation. What they didn't get was the environmental protection, and this gas station did a bunch of damage to. There was like a cracked gas tank, so there was a bunch of environmental remediation that the landlord was ultimately on the hook for. So you want to make sure that your client's protected and how to limit your risk and exposure and protect yourself. I brought up earlier, there's no safe days in state court in New York. That means once you have a judgment entered, the other side can execute. So an example I want to use real quick, I had a client, he couldn't face that he had $1 million judgment against him. And he wanted to post certain publicly traded securities as collateral to obtain the bond. This was great. He didn't want to sign the paperwork. He didn't want to fill anything out. He didn't want to do anything. And then he called me up saying that the sheriff has seized my assets. And the sheriff was entitled to their poundage, which I believe was like 5.5%. We were able to ultimately issue the bond, which is not always the case when the sheriff's involved, because once you get to that point, assets used to generally secure the bond are now restrained, right? We can't use them. So we were able to ultimately get him the bond. His attorney then had to motion the court to have the restraints lifted. So filing the bond and the notice of appeal did not automatically lift the restraints. Because of this, the client was out, I think, $55,000. I think the sheriff's poundage is 5.5%. So $55,000 to the sheriff, let's say another $20,000 in legal fees to their attorney. So because the client didn't have everything lined up ahead of time, because they didn't pre-qualify themselves for the bond, because they didn't sign everything in the given time, they had their assets restrained, and they ended up spending an additional like $75,000, which is a sunk cost they're not going to recoup because they didn't get it bonded in time. That's just something I wanted to mention. Moving on to, again, so I mentioned that the amount of the bonds differ by jurisdiction. New York State, we generally suggest 120% of the bond. Southern and Eastern District is 111%. The 120 for New York State doesn't appear in CPLR 5519, but because we have to take into account a little over 2 years post-judgment interest, we try to say 120% because it's a number that's very difficult to challenge. Moving on to the, and then in the Southern and Eastern District Court, that's set by an old clerk's rule. New Jersey, we suggest 105%. Texas is 105% by statute. California is 150% by statute of the final enter judgment. I'm giving these 5 examples so that you have an idea that bonds vary by jurisdiction. And again, the courts can set the bond amount by motion. This is all something to be aware of when your client needs the bond, and also when your client is the obligee on the bond. So moving on to receivership bonds, get added as an additional insured. If there's any insurance policies on the property or the actual business, make sure you're added as an additional insured. Rents receivers are very common. Business receivers are the new things, right? In divorce cases and various people that are trying to be a receiver of a judgment, be a receiver of a certain action. You're de facto a CFO and a CEO. I've seen clients be appointed to receive very expensive artwork. You want to be added as an additional insured. I had a client who was appointed a receiver of a gem company. He needed like a $20 million bond. I was not ultimately the bond agent because I insisted that he got added to the insurance policies. There was fidelity and theft and loss coverage for the various, multi-million-dollar gems in the company itself. And when he went to get added to the policies, the policy broker for the fidelity and fine gem policies required him to use his agency for the bond as well. I lost it because I insisted on the client limiting his own risk and exposure. And I believe, I'm not involved in the case, and I don't have this information firsthand, but I believe there were some items missing, right? So because he was added as an additional insured, he limited his risk of being dragged into a lawsuit. Filing and undertaking your bond, there's an e-filing system that Ari mentioned earlier. non-e-filed matters are generally with the county clerk. Federal matters, you need to be treasury listed. The notary needs to have a raised seal, and they usually require the original bond. This is my favorite part of the presentation, and I'm going to do my best to add as much information as possible. I mentioned earlier the bond has, right, it's issued by a surety. You want to make sure the surety is licensed. You want to make sure the attorney in fact is licensed. My office, myself, would be an attorney in fact for, let's say, Atlantic Specialty, SureTech Insurance Company, and I would sign the first or second page of the bond. My signature would be notarized. On the following page of the bond, there's what's called a power of attorney. That power of attorney grants my ability to sign the bond on behalf of that insurance company up to the dollar amount listed on the bond. You want to make sure that the bond amount is less or equal to the dollar amount listed on the power of attorney. You also want to make sure that the power of attorney has not been expired. And so if there is a undertaking is only signed by the surety, a bond is signed by the surety and the bond principal. If it's bond, you want to make sure the bond principal has signed the bond, their signatures their names printed below their signature with their title, and their signature is notarized on the following page. Also another thing, you want to make sure that the address for the surety is listed in the body of the bond, because if you win the case and you want to make a demand on the surety, you want to make sure that you have an address where you can send that formal demand. So this is why we want to verify that a bond is legitimate. And I had an attorney called me up and sent me a bond. He said, "What's wrong with this?" And I went through all the reasons why. So there were reasons why there was errors with the bond. When he went to make a demand on the surety turns out it was insolvent and wasn't even licensed to do business in New York State. So this attorney went to go make a claim on the bond to recoup $100,000. He made a claim. They said, we're in bankruptcy. There's no rehabilitation or liquidation. There's no money to pay you, and nothing was signed properly. We don't have any record of this, and they denied coverage. Now that was an appeal bond, and that attorney then had to take post-judgment execution efforts against the people, right? The judgment debtors. Then he had to do post-judgment execution efforts against them to recover money recover money instead of recovering against a bond because the bond was illegitimate. Now, if that was a legitimate bond, he would have sent a formal demand. They would have sent him a check within 5 to 10 days, and he would have collected his $100,000, went on his merry little way. Instead, he has to then try to do post-judgment execution efforts against people who committed fraud, and they probably, sent out their assets, right? Whatever you want to call it, hid their assets. So we're going over why verifying a bond. So the surety bond fraud is on the rise, right? If you have a bond filed with the court clerk's not checking to make sure that it's a legitimate bond. They're not checking to make sure the surety is licensed. They're not checking to make sure that the attorney, in fact, is not disbarred from the insurance industry. And I bring that up because Con Edison accepted a bunch of liens on behalf of a general contractor that had a bunch of his subs and suppliers file liens. The bonds were accepted. No one challenged it. The general contractor got paid their retainage. They dispersed the funds. They entered bankruptcy. The subs and suppliers eventually went to make a claim on the bonds. The bonds were issued by a complete fraudulent company, and Con Edison, I believe, ultimately paid out the money on the bonds, and they made them whole. Now, if someone verified, are these bonds legitimate? Are they issued by a legitimate company? The answer would have been no. They would have kept the retainage, and they could have used that to satisfy the subs. Another thing I want to bring up, a lot of times attorneys ask me to check bonds for accuracy, and I don't get paid for that service, right? I don't get paid for the service saying why you should verify a bond. But if you look at the bond should flow. Does it make sense? A lot of times, let's say even with my office, I take a prior bond I use, I add in the caption, I add in a different bond number, the index number, and I start drafting it down to make sure that it makes sense and that it applies to this case. I'm not reinventing the wheel. But a lot of, let's say, companies that maybe are a little bit fast and loose, they may do that, but they don't look at their work and they issue a bond that doesn't make any sense. So I was talking with a client about a discharge of mechanics lien, and it said, where is by a stipulation? I asked the client, can I have a copy of the stipulation so I can compare it to the stip? And he said, there is no stipulation. So why would he accept the bond that starts off with referencing a stipulation that does not exist? Does this mean that there wouldn't be coverage or actual protection by the bond? Probably not, but I'm not a lawyer and I don't want to comment on whether or not there's coverage. But you also don't want to have the conversation with your client. There should be coverage. You're probably protected. Those should, would, probably are not exactly words that your client's going to be happy. Another example to just wrap it up, you want to make sure the bond makes sense. There's an address and there's all this stuff. I actually have a guide on how to verify bonds. If you send me an email, I can email you that guide. I was called in by a AM Law 100 firm, one of the best in the world, and they said, hey, we got a security in an international arbitration case. The judge ordered the other side to post a bond. We got this alternative security. I think it was called alternative security. So they sent me a copy of it, and they said, why does this not make sense? And I brought them to the reasons, and they said, could you make an expert witness statement on that we could file in this arbitration? So I spent all night drafting this, and the main point of the statement was that the alternative security that the other side got, so my client should have been the obligee. The alternative security had the other side's client as both the principal and the obligee. So the security was payable back to their own client. And it's laughable that someone thought that they could pull this off and submit this in a $200 million litigation. But I'm not exactly surprised that someone tried to play it off. So if there's something filed, don't just accept it as, okay, there's a bond, it says it's filed, we're protected. Verify that it makes sense, verify that it protects your client, verify that it matches the statute that it's pursuant to, because if it doesn't, you may have unbonded exposure, and you would want to challenge that and have that thrown out in court. My name's Neil Peterson. I'm with Peterson & Sons Bonding. I have a passion for what I do. I really, really enjoy bonding, and I thank you for having me today.
And I want to just wrap up by saying that you really should consider Neil a resource. I would say maybe 7 out of 10 phone calls that I place with Neil are actually ordering a new piece of business. And Neil is always welcoming. He really does like it if you have just something of interest. He'll take the call just out of professional curiosity and love to talk to you about it, and you could work through your issues with him. But as you got to it at the end, you should not think that dealing with a bonding agent or dealing with Neil is only when your client needs to get the bond. If your client's on the receiving end, if it's going to be owed something and that obligation is going to be covered by a bond, you really should be talking to a knowledgeable agent as well to do the things that you'll miss. And like Neil said, it's not that a mistake in a bond will automatically prevent payment, but when you have to spend another 3 more months before it's collectible, the client's going to hold that on you and not on the bonding company or the surety that issued the bond. And like Neil, thank you for your time today, and I hope to hear from you.
Thank you both for joining us. This was a really informative discussion. And just again, just a quick shout out to our main sponsor, Riverside Abstract, Riverside 1031, and Riverside Tax. You will get just a follow-up email from us with how you can get in touch for any title or 1031 or tax or Riverside Tax needs. So thank you all for joining us today, and we look forward to seeing you again.